Hello, my name is Lorraine Lee. I am the Chief Administrative Law Judge of the Washington State Office of Administrative Hearings. The Washington State Legislature in 1981 established our agency to provide citizens with an impartial forum to present their case and be heard in disputed matters with government agencies. Our mission is to independently resolve administrative disputes between citizens and state agencies through accessible, fair, prompt processes and issue sound decisions. The administrative law judges and employees of the Office of Administrative Hearings are dedicated to provide professional, competent, and high-quality services to everyone and all parties who appear before us. We hold ourselves to the highest level of ethical standards. Treating everyone with dignity and respect is our core value. In a year's time, more than 70,000 hearing requests are handled by the Office of Administrative Hearings. The great majority of these cases involve disputes that have a direct impact on the livelihood and well-being of the parties. We understand how important it is that these matters are resolved promptly. We are committed to issuing orders and rulings that are legally sound and well-reasoned, based on the evidence and information presented in the hearing and based on the relevant law and regulations. Our hearings are informal. Parties do not need to be represented by a lawyer. To help parties prepare for the hearing, this video shows what happens in a typical hearing held by the Office of Administrative Hearings.
Hello, I'm Jane Habiger, an Assistant Deputy Chief Administrative Law Judge with the Office of Administrative Hearings. We produce this video to help you prepare for and understand what happens during a child support hearing. The hearing process is an opportunity for you to be heard. It is conducted by the Office of Administrative Hearings, an independent agency not affiliated with the Department of Social and Health Services. The hearing will be conducted by an impartial administrative law judge who will then make a decision about your case. Events leading up to a hearing might follow this pattern. First, a custodial parent goes to the Division of Child Support, or DCS, to ask them for help to establish and collect child support from the other parent of their child or children. Next, DCS sends both parents a notice and finding of financial responsibility, which states how much the non-custodial parent must pay. If either parent disagrees with this amount, they can ask for a hearing. Then, OAH will mail the parents a notice of hearing setting a hearing date. Before the hearing, both parents must provide their current pay stubs and their last 2 years of income tax returns. All parties will receive copies of the documents prior to the hearing. These documents will also be submitted to the administrative law judge. Preparation is key. Take time to review the documents for your hearing and to think about what you want to tell the administrative law judge and what you want to ask the other parent or witnesses. You can bring additional documents to your hearing if you have not mailed them in advance, and you can also bring witnesses to the hearing. Most hearings occur over the telephone. The ALJ calls the parents and the DCS claims officer at the DCS office for the hearing. Parents may also participate in the hearing by telephone from a different location, such as their home or work. The hearing you're about to see, however, is an in-person reenactment of a child support hearing. The mock hearing participants will be Judge Ng as the administrative law judge. Christy Jones is the claims officer with the Division of Child Support. Veronica Garcia is the non-custodial parent, and Robert Rowe is the custodial parent.
Good morning, Your Honor. Ms. Garcia, would you have a seat across the table, please? And Mr. Rowe, you may be seated next to my left here, sir.
Good morning, everybody.
Good morning, Your Honor.
My name is Joan Ng, and I'm the administrative law judge who will be conducting the hearing this morning. Ms. Jones, would you please introduce yourself and the parents?
Yes, Your Honor. My name is Christy Jones. I'm a claims officer with the Department of Social and Health Services, DSHS, Division of Child Support, or DCS as we often refer to it. Present across the table for me is the non-custodial parent and mother of the child, Veronica Garcia. To my left is the custodial parent and father of the child, Mr. Robert Rowe.
Good morning. Ms. Garcia, did you receive a copy of the exhibits for the hearing today?
I did, yes.
And did you bring any others with you?
I did. I have a copy of my 2009 tax return.
Ms. Jones, has the department received a copy?
Yes, you have, Your Honor. It's marked as Exhibit 6.
Okay. And Mr. Rowe, have you seen it?
Yes, Your Honor.
Okay. And Mr. Rowe, did you receive the exhibits for the hearing?
Yes, ma'am.
And did you bring any more with you today?
No, ma'am.
Okay. In a minute, I'm going to turn on a digital recorder to start the hearing. Is everyone ready?
Yes, ma'am.
Yes, ma'am.
DCS is ready.
I've turned on the digital recorder and we've started the hearing. I will be making a CD from the recording after this hearing is over, and each of you has a right to a copy of that CD if you'd like one. This is an administrative hearing in a child support matter. My name is Joan Eng, and I'm an administrative law judge with the Office of Administrative Hearings. The Office of Administrative Hearings is a separate state agency from the Department of Social and Health Services. I don't work for the Department of Social and Health Services, and I don't work for the Division of Child Support. The docket number in this matter is 10-2010-C-0430. The date today is March 30th, 2010. And right now it's about 8:50 in the morning. I'm conducting this hearing at the Olympia office of the Office of Administrative Hearings. Appearing today are Ms. Christy Jones, who is an attorney and who represents the Department of Social and Health Services in this matter. Also appearing today are Ms. Veronica Garcia, who is the mother and the non-custodial parent, and Mr. Robert Rowe, who is the father and the custodial parent. Would each of you please state and spell your names for the record? Ms. Jones?
Yes, my name is Christy Jones, CHRISTY-JONES.
Okay, thank you. And Ms. Garcia?
Veronica Garcia, VERONICA,
Thank you. And Mr. Rowe?
Robert Rowe, ROBERTROE.
Thank you. Now I'd like to explain to the parties what their hearing rights are. Ms. Garcia and Mr. Rowe, each of you has the right in this hearing to be represented either by an attorney or by another representative of your choice, like a family member or a friend. If you'd like to be represented by an attorney, it would have to be at your own expense, because this isn't a criminal matter, so the state isn't required to provide an attorney to represent you. If you're on a limited income, you may qualify for a legal services attorney who will represent you for free. There's a phone number that you can call to ask about legal services attorneys. Ms. Garcia, would you like to have a representative present today, or would you like to represent yourself?
I will be representing myself, thank you.
And Mr. Rowe?
I'll represent myself also.
Okay. Let the record reflect that both the parents are waiving their rights to representation in today's hearing. Now I'd like to explain a little bit about one of the purposes of a hearing. Now, what we're doing here today is we're creating a hearing record, and that has two parts. The first part is an audio recording. As I mentioned a few minutes ago, I turned on a recorder and it's going to remain on for the rest of the hearing. The second part of the hearing record are the exhibits, which are the written documents that I asked everyone about a few minutes ago. When I make my decision in this case, I'm allowed to consider only what's in the hearing record, in other words, the combination of what's on the recording and what's in the exhibits. So if there's something you want me to know, it's important that you either say that during your testimony or you point it out in the exhibits. Ms. Garcia, do you have questions about what I've just explained?
No, ma'am.
And Mr. Rowe?
No, ma'am.
Okay. Now, the next thing I need to do is swear in the parties, because the testimony in this hearing is required to be given under oath or affirmation. Would each of you please raise your right hands? Does each of you swear or affirm that the testimony that you give today will be the truth, the whole truth, and nothing but the truth? Ms. Jones?
I do.
Ms. Garcia?
Yes, ma'am, I do.
And Mr. Rowe?
I do.
Thank you. Now, the testimony in this hearing is subject to cross-examination, and that means that after one person is finished giving testimony, the other two will have an opportunity to ask questions about what they just talked about. Now, let me emphasize that questions aren't the same as statements. Each of you will have a chance during this hearing to give your own testimony, and when it's your turn to give testimony, it will be addressed to me. Ms. Garcia, do you have questions about what I've just explained?
None. No.
And Mr. Rowe?
No, ma'am.
Thank you. Now I'd like to clarify the hearing issue to make sure we all have the same understanding of it. My understanding is that we're here to discuss the current and the future child support for one child, as well as any past due support that Ms. Garcia may owe. Is that your understanding of the hearing issue, Ms. Jones?
Yes, Judge.
And Ms. Garcia?
That is correct, Your Honor.
And Mr. Rowe?
Yes, ma'am.
Okay.
then we're ready to get started here. The first thing I'd like to do is deal with exhibits, and I think everybody indicated that they have received copies of those. Now, I am going to identify each one, and then I'm going to ask each person if they have questions about it, and then I'll ask if they have objections. The kinds of objections that I can recognize and rule on are the ones that are found in the rules of evidence. So, for example, if you think a document is irrelevant or unduly repetitious, if you don't agree with what's actually written in a document, you don't have to object to it to let me know that you disagree with it. For example, I understand that you may not agree with the $150 that's included in the Notice and Finding of Financial Responsibility, because that's why you asked for this hearing. So let's go through the exhibits now. I have marked as proposed exhibit number 1 the Notice and Finding of Financial Responsibility, in which the department has determined that $150 a month is the appropriate amount of support for one child, Destiny Rowe, who is only 6 months old. Attached to that are the department's version of the Washington State Child Support Worksheets that shows how they came up with that calculation. Ms. Jones, does the department have an objection?
No objection, Your Honor.
Ms. Garcia?
Well, I do object to the amount, Your Honor. I mean, I love my daughter and I do want to support her, but $150 is too much money. I can't afford it.
And I understand that's why you asked for the hearing today.
Mm-hmm.
Do you have an objection to including it to show what the department's proposal is in terms of how much you should be paying? I'm going to be making my own decision about how much money should be paid, but I won't be doing that until after I've heard the testimony from everybody.
That's fine.
Mr. Rowe?
No objection, Your Honor.
Proposed Exhibit 1 is admitted. Proposed Exhibit 2 is proof that this notice was served on Ms. Garcia on November the 15th, 2009. Ms. Jones?
No objection.
Ms. Garcia?
No, ma'am.
And Mr. Rowe?
No objection.
Proposed Exhibit 2 is admitted. Proposed Exhibit 3 is a copy of Ms. Garcia's objection and request for today's hearing. Ms. Jones?
DCS has no objection.
Ms. Garcia?
No, ma'am.
Mr. Rowe?
No objection.
Proposed Exhibit 3 is admitted. Proposed Exhibit 4 is information from the Employment Security Department that shows Mr. Rowe's 2009 earnings. Ms. Jones?
No objection, Your Honor.
Ms. Garcia?
No, ma'am.
Mr. Rowe?
No objection.
Proposed Exhibit 4 is admitted. Proposed Exhibit 5 is also information from the Employment Security Department that shows Ms. Garcia's 2009 earnings. Ms. Jones?
No objection.
Ms. Garcia?
No, ma'am.
Mr. Rowe?
No.
Proposed Exhibit 5 is admitted. Proposed Exhibit 6, the last one, is a copy of Ms. Garcia's 2009 federal income tax return as well as a March pay stub. Ms. Jones?
No objection, Judge.
Ms. Garcia?
No, Your Honor.
Mr. Rowe?
No objection.
Proposed Exhibit 6 is admitted into the record. So all of the proposed exhibits 1 through 6 are in the record, and we're done with exhibits. So now it's time to turn to testimony. Let me explain a little bit about how that section is going to work. Each person will have a chance to give testimony on their case. I'm going to ask Ms. Jones to go first on behalf of the department. After she's done, each of the other two parties will have a chance to ask her questions on cross-examination. After the department's testimony and cross-examination are done, then Ms. Garcia, it's your turn to give testimony on your case. And I'm going to ask you to go next because you're the person who asked for today's hearing. After Ms. Garcia is done, each of the other two parties will have a chance to ask her questions on cross-examination. And then, Mr. Rowe, it'll be your opportunity to give testimony on your case with the other two parties asking you questions on cross-examination after that. Now, I may have questions for any or all of you because I want the record to be as complete as possible before I make my decision. At the end of all the testimony, I'm going to give each person the chance to make a closing argument if they would wish to. This is your chance to either sum up your case or to tell me anything else you didn't have a chance to say earlier. And finally, I won't be making a decision in this case today. I'll be doing that later in writing, and I'll explain more about that when we reach the end of the hearing. Ms. Garcia, do you have any questions about how testimony works?
No, ma'am.
Mr. Rowe?
No, I think that's clear.
And Ms. Jones, would you please present the department's case?
Certainly, Your Honor. This case began when we received a referral from the local community service office, which shows that Mr. Rowe began receiving public assistance through the TANF program, the Temporary Assistance for Needy Families program, for the child Destiny here on October 1st, 2009. The Division of Child Support subsequently prepared the notice and finding of financial responsibility with the attached worksheets, and this is Exhibit 1 in the packet. And then those documents were served on Ms. Garcia on November 15th, 2009, as shown in Exhibit 2. Before preparing the notice, DCS obtained information from the Employment Security Department, which showed as Exhibits 4 and 5, and you can see that these show that the employment history for Ms. Garcia is somewhat spotty, and it does further show that in the past when she has worked, she has only made minimum wage. The department also just learned this morning that apparently Ms. Garcia has 2 other children who reside with her, I believe. This is a fact that we were not aware of until the pre-hearing meeting that was held this morning prior to this hearing.
Ms. Garcia, do you have any questions you'd like to ask Ms. Jones?
Not right now, no.
Mr. Rowe, do you have questions?
I don't think so, at least not now.
Ms. Jones, would the department like to call any witnesses?
Yes, we'd like to call Ms. Garcia first. Ms. Garcia, would you please take a look at Exhibits 5 and 6?
Okay.
Do you agree that your 2009 earnings are recorded as nearly being the same in both the Employment Security Department information as well as your tax return?
Yes.
I don't see any deductions except taxes and the FICA here, the Federal Insurance Contribution Tax, on your pay stub.
That's because I don't have any.
You told me earlier today that you have 2 children. Would you please tell the judge the names and ages of those children?
There's Seth, he's 6, and Laura, who's 3.
And do they both live with you?
Yes, ever since my ex-husband and I split up.
Ex-husband? You never told me
It's
about
none
that.
of your business,
Please.
first off.
Ms. Jones, would you please continue?
Okay. When was that breakup?
2 years ago, we got a divorce last year.
Does he pay child support for either of the children?
No, I don't even know where he is. He's probably still off with that girlfriend he ran away with.
Do you work full-time?
Most of the time, yes. If there's nothing to do, my boss lets me go home early.
Do you ever work any overtime hours?
Twice a year, maybe. My boss says it costs too much, so he doesn't like to let me do it.
Okay. DCS has no further questions for this witness, Your Honor.
Mr. Rowe, do you have any questions you'd like to ask Ms. Garcia?
No.
Ms. Garcia, do you want to present any more testimony?
Like I said, I think $150 is too much money. I shouldn't even have to pay child support when he won't even let me see my own daughter.
That's not true. You see her every
You wouldn't even let
Saturday.
me keep her overnight.
Ms. Garcia.
You're not the one who
Mr.
has to-
Rowe.
You don't let me take
Ms.
care of her.
Garcia, please don't interrupt Mr. Rowe. Right now, it's Ms. Garcia's opportunity to give testimony. You'll have a chance in a few minutes to give your own testimony. Ms. Garcia, please continue.
I just want you to make him let me see my baby more.
I'm afraid I don't have that authority. I only have the ability to make decisions about child support issues. If you and Mr. Rowe can't agree about visitation issues, there's something called a parenting plan, but you need to get a different judge in Superior Court to order that. I don't have the power to do that.
I'm sorry. I thought this was court hearing.
No, this is an administrative child support hearing. And I only have the ability to make decisions about child support. For example, whether or not it should be paid, and if so, how much. Is there anything else you want me to know about that issue?
No, it's fine.
Okay, I do have a few questions to ask you. Do you live with any other adults?
My boyfriend, yes.
And does he work outside the home?
No, he just quit. He stays at home while I go to work.
And are you married?
No, I'm not married.
Do you have medical insurance for Destiny?
I can't even get it for myself.
Do you know how much it would cost to get to cover Destiny?
No.
I just have one last question. Do you have any extraordinary debts or expenses that you didn't voluntarily incur?
My new pickup. It's $600 a month for car payments. And rent is $450 a month. And I'm very behind on my electric bill. It was just a really cold winter.
Well, those are ordinary expenses that everybody incurs, and some of them you incurred voluntarily. I was thinking more about things like maybe medical bills or lawyer bills that you didn't have any control over.
My brother did my divorce papers. He's a lawyer, and he just charged me the filing fee, so it wasn't that bad. But I broke my leg last year at work. I had to have an operation. It was pretty expensive.
Since it was at work, did the Department of Labor and Industries pay for the medical bills?
Well, yeah.
So you don't have any medical expenses from that?
No, the state paid.
Okay. Thank you. I don't have any more questions. Ms. Jones, does the department have any more questions?
No other questions, Judge Yang.
And Mr. Rowe, do you have any more questions to ask Ms. Garcia?
Not now.
Ms. Jones, does the department have any more witnesses?
No, Judge Yang.
Okay, so Mr. Rowe, now's your opportunity to give testimony on your case.
Well, Your Honor, I know Veronica tries to be a good mother. I've seen her with the kids a lot. But Destiny is just a baby. She's too young for overnight. And I know Veronica loves her child. And I'd like her to be part of Destiny's life. And she is. She visits every Saturday. She comes to my place at 9 o'clock in the morning and spends time with Destiny, playing with her and feeding her. And that's enough for right now.
Okay. Is there anything else you'd like me to know?
No, that's it.
Okay. Ms. Jones, does the department have any questions for Mr. Rowe?
Just a couple. Mr. Rowe, are you currently employed?
No, I stay home and take care of Destiny. I go to grad school. My mom takes care of her when I'm in school.
And you pay your mother to do that?
No, she just likes doing it.
And Mr. Rowe, do you receive medical assistance for Destiny through the TANF grant?
Yeah.
That's all I have, Your Honor.
Thank you. Ms. Garcia, do you have any questions for Mr. Rowe?
No, none.
Okay. Mr. Rowe, I have a couple questions for you. Are you married?
No, I live with Destiny, and my mom lives just down the street.
Do you pay anybody for child care?
No, just my mom takes care of Destiny. I don't trust daycares.
Do you have any other children?
No.
And how old are you?
46.
Ms. Garcia, I forgot to ask, how old are you?
I'm 30.
Okay, I don't have any more questions. Ms. Jones, does the department have any more questions for either Ms. Garcia or Mr. Rowe?
No, Your Honor.
Ms. Garcia, do you have any more questions?
No, ma'am.
Mr. Rowe?
No, thank you, Your Honor.
That's the end of testimony, and we're going to move to closing argument. As I mentioned before, I'm going to offer this to each person if you would like to take this opportunity to either sum up your case or tell me anything you didn't have a chance to say before. Ms. Jones.
I'll be brief, Your Honor. Basically, DCS did not know about Ms. Garcia's other children when we prepared the notice, but I know that you'll take that into account when you issue the written decision. Thank you.
Ms. Garcia, would you like to make closing remarks? This is going to be your last opportunity to speak before the end of the hearing.
I'd just like to ask you to make a fair decision.
Thank you. Mr. Rowe, would you like to make a closing argument?
No, thank you, Your Honor.
Okay, so that's the end of closings. Let me explain what's going to happen from here on out. As I mentioned earlier, I won't be making a decision in this case today. I'll be doing that later in writing. Within the next 3 weeks, I am going to issue what's called a final order, and a copy will be mailed to each person. Everyone's appeal rights are going to be explained in the final order, but I'm going to go over those briefly now in case there are any questions. You don't have to memorize or write down what I'm about to say because it's all going to be included in the final order. There are 2 ways to appeal my final order, and the first is called reconsideration. And that's if someone disagrees with my final order, they can ask me to reconsider it. The request has to be made in writing, and it has to include an explanation for why you're asking me to reconsider. The written request has to be received by my office within 10 days of the day that my final order is mailed out, and the day of mailing is stamped on page 1. The 10 days are counted on a calendar, so they do include Saturdays, Sundays, and holidays. If my office receives a timely request for reconsideration, we're required to make copies of it and send them to the other 2 parties to give them a chance to respond. Each of them has 7 business days from the day that the copy of the request was mailed out to have their responses back to my office. The law then says that I have 20 days from the day I initially received the timely request for reconsideration to make a decision about it. Now, the second kind of appeal is only available to Ms. Garcia and to Mr. Rowe. It's not available to the department. The second kind of appeal is filing an appeal in Superior Court.
I'm sorry, quick question. Do I have to ask you to reconsider your final order before I can appeal to Superior Court if I disagree with your final order?
No, you don't. If you want to file in Superior Court, you have 30 days from the day that the final order is mailed out to do that. And you don't have to ask for a reconsideration before you file in court. However, if anybody requests reconsideration, that process has to be over before anybody can file in Superior Court. During the time that the reconsideration is working its way through the process, the 30-day deadline isn't being counted. The 30 days doesn't start to be counted until the reconsideration is over. Ms. Garcia, do you have any other questions about your appeal rights?
No, that's all. Thank you.
Mr. Rowe, do you have any questions about your appeal rights?
No, Your Honor.
And Ms. Jones, are there any last comments from the department?
No, Your Honor. I think the record's complete.
I'd like to thank everyone for their time today. The time right now is about 9:30 in the morning, and we're adjourned. Thank you, everyone.
Thank you, Your Honor.
For further information, please review your hearing rights in a DSHS case. This brochure is mailed out with your notice of hearing. In it, you will find valuable information that may help you prepare for your hearing. Our website also has helpful information. Please visit www.oah.wa.gov and select DSHS on the page.